It's kind of bizarre. I wish we knew all the context of the phone calls. Defense motion to strike and or allow the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. On October 6, 2023, the state of Florida filed a motion to allow former testimony of state witness Felicia Holmes based on her perceived unavailability. So Mariah Hamilton's mother, who testified in the first trial, they want to show her entire testimony to the jury in the second trial. Felicia Holmes is unavailable for the upcoming trial, and further alleges that Felicia Holmes refuses to testify and has indicated she will invoke her right to remain silent. This court should be aware that Felicia Holmes previously sat for a deposition in which she answered all questions posed to her. Ms. Holmes answered all the questions asked of her in the defense first trial. Ms. Holmes testified at the trial both Mark Moretti and Christine Bradley threatened her and that she was scared of Miss Bradley, so it is confounding to believe that Felicia Holmes is now being told to invoke any protection under the Fifth Amendment by the same office has personally engaged in the conduct that undermined the willingness of Felicia Holmes to take the stand. The state has utterly failed on the face of their motion to show the circumstances under which the witness Felicia Holmes can assert her purported Fifth Amendment claim. The motion fails to allege the circumstances regarding Holmes asserting her right to invoke the Fifth, other than she refuses to testify. Adding insult to injury, after finding the subject motion undersigned discovered that after a pretrial conference with Felicia Holmes, Christine Bradley sent the following email to attorney Christopher Barris. So in this email, Christine Bradley's emailing Felicia's lawyer, it looks like. The case law is clear that Fifth Amendment cannot be invoked, but must be done at the time of the questioning. I tried to call. My current thought would be that I would file a motion to have her declared unavailable for trial and then seek to admit her prior testimony if she is going to persist, refuse, and answer questions, despite the immunity that comes from the subpoena. If that motion for unavailability is granted, then there would not be any further reason to have her on the ankle monitor. The following day after this email was sent, Bradley proceeded to file and prepare the subject matter motion to allow firmer testimony of Felicia Holmes. So they're saying Bradley lied about something here. The email authored by Bradley is in direct contravention of the rules of ethics, which prohibit attorneys and especially prosecutors from instructing witnesses what to testify to under oath and whether or not to testify. It is important to note that Bucklew was further ordered to provide all emails between Bradley and Barris, and the specific email was intentionally withheld from the state's discovery submission. Ooh. So they asked for shit from Bucklew and she never sent this over. The ongoing misconduct the prosecutor assigned his case have been nothing less than consistently deceitful to the court and to the defense and cannot continue to be ignored, unsanctioned, or unpunished. It is patently improper for anyone in the office of the state attorney to advise their witness to exercise their Fifth Amendment rights solely in an effort to have her declared unavailable. I understand now. That's actually crazy. That's insane, right? In the case at hand is the actions of the state attorney that have caused the witness to feel intimidated and thus afraid to testify solely because of their own actions. Rather than not call the witness, the state attorney's office solicited the testimony of said witness in exchange for a benefit, an effort to support the motion filed by the state attorney the following day. So he's saying it was a whole big plan to support the motion the following day. That's crazy. Bradley was removed from this matter days later from his conduct stemming from her cover-up of Mark Moretti's wrongdoings. Nonetheless, the subject matter motion has been adopted by the current prosecution team.